context.
Ms. Stevenson, I want to ask you what Justice Kagan called the mirror image question, and Mr. Mupon and Judge Hartz's example about homosexuality in the 1970s was professionally considered to be a mental health disorder. What if a state back then might have passed a law prohibiting talk therapy that affirmed homosexuality? Would that be subject to rational basis review on your theory?
So, Your Honor, what our theory depends on is that there is a treatment being provided that's being regulated, and that the regulation is consistent with the standard of care.
Let's check both of those boxes in our hypothetical.
Then yes, and I want to return to Justice Jackson's point because
so yes,
they could regulate.
The state could forbid a regulated licensed professional from affirming homosexuality
if that were
consistent with the then prevailing standard of care.
That's right.
And so likewise, if the prevailing standard of care were to change or to solidify that this sort of talk therapy is beneficial to minors or at least not harmful to minors, then a state could pass a mirror image statute to Colorado's that prohibits any attempt to affirm changes of gender identity or sexual orientation, and that would be subject to mere rational basis review on your theory.
That's right, Your Honor. And just to illustrate, it's not the fact that there are words involved doesn't make a difference. So states, like we recognized in Scarametti, have the power to regulate even in the face of medical uncertainty. The laws or the standard of care could change there, and the legislature can act to change that. And
so even in cases where medical uncertainty exists, you think that the state could pass such a law prohibiting ex ante speech that would affirm gender identity changes or sexual orientation changes or homosexuality?
I don't think you have to reach that question in this case because
I'm asking about the logic of your argument. I think you just said states can regulate even in the absence of medical consensus in this fashion. Is that right?
Where there are no words involved and no First Amendment issue raised. And
I'm asking, we're talking about speech and we're talking about therapy, talk therapy. That's what I want to get at. And I think you're saying that if there's medical consensus, states surely could pass mirror image laws. And I think you're saying, but I want to make sure, that even in cases where there's medical uncertainty, the state could so regulate.
You could reach a holding in this case that said, yes, treatment is treatment, and this can be, it doesn't matter whether it's consistent with the standard of care or not. We would urge you to reach a narrower holding in this case.
I understand that, but I'm asking you to answer my question. Could a state, when there's medical uncertainty, and we normally provide, this court has many times said, when there's medical uncertainty, we defer to state judgments. And I think you're saying that yes, I think the logic of your position has to be yes, and I'll let you go as soon as you give me an answer up or down on the state of medical uncertainty and whether they could pass mirror image laws.
I think it's less clear that that fits into the historical tradition identified in NIFLA that calls specifically out malpractice, which is an enforcement of the standard of care. And while that question could come up in another day here, where we meet the standard of care, we don't think we need to reach it.
Counsel, it's pretty important.